Yes.
If you could, please point to that individual, identify a piece of clothing that they're wearing.
Gentleman with the three-piece suit and the letters red. I think it's a tie, I'm not sure what it is.
An ascot. Okay, he corrected me. It's an ascot. If the record can reflect the identification of the defendant, Your Honor.
So reflected. Ladies and gentlemen, the jury, you are admonished that no juror may declare to a fellow juror any fact relating to this case of his or her own knowledge, and if any juror discovers during the trial or after the jury is retired that he or she or any other juror has personal knowledge of any fact in controversy in this case, he or she shall disclose that situation to myself in the absence of the other jurors. This means that if you learn during the course of this trial that you are acquainted with the facts of this case or the witnesses and you've not previously told me of this relationship, you must then declare that fact to me. I do want to remind you, we do have an impaneled jury now. So myself, the attorneys, the parties, the staff in Department 12, with the exception of Officer Hawks, are not permitted to have any communication with you whatsoever outside of the courtroom. We're going to be together for the next several days. We will probably see each other coming in and out of the courthouse, maybe in the elevator. Please do not be offended should we not acknowledge you or speak to you. We are all just maintaining our ethical obligation to maintain the integrity of the jury system. So if there's anything you need to discuss with the court, I mean, you can go to Officer Hawks, or you do so in the courtroom in the presence of both sides. What I will now say is intended to serve as an introduction to the trial of this case, is not a substitute for the detailed instructions on the law, which I will give you at the close of the case and before you retire to consider your verdict. This is a criminal case commenced by the state of Nevada, which I may sometimes refer to as the state, against the defendant, Mr. Kim Blandino. The case is based on an amended indictment. The clerk will now read the amended indictment and state the plea of the defendant to that indictment.
District Court, Clark County, Nevada, State of Nevada, Plaintiff versus Kim Dennis Blandino, Defendant, case number C341767, Department number 12, amended indictment, State of Nevada, County of Clark, the defendant above named Kim Dennis Blandino, accused by the Clark County Grand Jury of the crimes of extortion, felony, and impersonation of an officer, gross misdemeanor, committed at and within the County of Clark, State of Nevada, on or between April 8th, 2019, and May 21st, 2019, as follows. Count 1, extortion. Did then and there willfully, unlawfully, and feloniously, and with the intent to extort or gain any money or other property, and or to influence the action of any public officer, whether or not the purpose is accomplished, threaten, directly or indirectly, to accuse any person of a crime and or to expose or impute to any person any deformity or disgrace to it by making a demand to Michael Federico, a Las Vegas Municipal Court Judge Pro Tem, for $25 and or enrollment in the Ethics, Fairness, and Security in Your Courtroom and Community class, or in the alternative, pay $500 to the Clark County Law Library and or provide defendant an apology, including in writing and or in public, and if Michael Federico did not complete this class, pay this money and or provide said apology, defendant would file complaint and or allegations against Michael Federico with the Commission on Judicial Discipline and or would file a criminal complaint with the FBI accusing Michael Federico with a misdemeanor crime under 18 U.S.C. 242 and or would send documentation of Michael Federico's alleged misconduct to the law firm of Olson, Cannon, Gormley, Angulo, and Stobersky, where Michael Federico is employed. Count 2, impersonation of an officer. Did willfully, unlawfully, and falsely impersonate a public officer, civil or military, or a police officer, or a private individual having special authority by law to perform an act affecting the rights or interests of another, to wit, an investigator for the State of Nevada Commission on Judicial Discipline, and in such assumed character did an act purporting to be official, whereby another is injured or defrauded by identifying himself verbally and or in writing to one or more persons, including Michael Federico and or P. Marwitz, as an unpaid and or volunteer investigator for the State of Nevada Commission on Judicial Discipline. Dated the 2nd day of March 2022, Stephen B. Wilson, Clark County District Attorney, signed by Michael R. Dickerson, Chief Deputy District Attorney, to which the defendant has pled not guilty.
Thank you very much. This case is based on an indictment which just has been read to you by the clerk of the court. You should distinctly understand that the indictment is simply a charge and that it is not in any sense evidence of the allegations it contains. The defendant has entered a not guilty plea to the indictment. The state therefore has a burden of proving each of the elements as alleged in their charging document by proof beyond a reasonable doubt. When Mr. Blandino sits here today, he is presumed innocent. The purpose of this trial is to determine whether the state of Nevada will meet their burden of proof. It is your primary responsibility as jurors to find and determine the facts. Under our system of criminal procedure, you are the sole judge of the facts. You are to determine the facts from the testimony you hear and the other evidence, including exhibits introduced in court. It is up to you to determine the inferences which you feel may be properly drawn from the evidence. The parties may sometimes present objections to some of the testimony or other evidence. It is the duty of a lawyer to object to evidence which he or she believes may not properly be offered, and you should not be prejudiced in any way against a lawyer who makes objections on behalf of the party he or she represents. At times, I may sustain objections or direct that you disregard certain testimony or exhibits. You must not consider any evidence to which an objection has been sustained or which I have instructed you to disregard. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Remember, statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulated as to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proof. You must not speculate to be true any insinuations suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must not be influenced in any degree by any personal feeling of sympathy for or prejudice against the state or the defendant. Both sides are entitled to the same fair and impartial consideration. In considering the weight and value of the testimony of any witness, you may take into consideration the appearance, attitude, and behavior of the witness, the interest of the witness in the outcome of the case, if any, the relation of the witness to the defendant or to the state, the inclination of the witness to speak truthfully or not, and the probability or improbability of the witness's statements and all of the facts and circumstances in evidence. Thus you may give the testimony of any witness just such weight and value as you believe the testimony of that witness is entitled to receive. There are two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is testimony or exhibits which are proof of a particular fact from which, if proven, you may infer the existence of a second fact. You may consider both direct and circumstantial evidence in deciding this case. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. Opening statements and closing arguments of the attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. No statement, ruling, remark, or comment which I make during the course of this trial is intended to indicate my opinion as to how you should decide this case or to influence you in any way in your determination of the facts. At times, I may even ask questions of witnesses. If I do so, it is for the purpose of bringing out matters which I feel should be brought out and not in any way to indicate my opinion about the facts or to indicate the weight I feel you should give to the testimony of the witness. I may also find it necessary to admonish the attorneys, and if I do, you should not show prejudice against a lawyer or his or her client because I have found it necessary to admonish him or her. Until the case is submitted to you, you must not discuss it with anyone, even with your fellow jurors. After it is submitted to you, you must discuss it only in the jury room with your fellow jurors. It is important that you keep an open mind and not decide any issue in the case until the entire case has been submitted to you under instructions from the court. The trial will proceed in the following manner. The Deputy District Attorney will make an opening statement, which is an outline to help you understand what the state expects to prove. Next, the defendant's attorney may, but does not have to, make an opening statement. Opening statement serves as an introduction to the evidence which the party making the statement intends to prove. The state will then present its evidence, and counsel for the defendant may cross-examine the witnesses. Following the state's case, the defendant may present evidence, and the Deputy District Attorney may cross-examine the witnesses. However, as I have said, the defendant is not obligated to present any evidence. After all the evidence has been presented, I will instruct you on the law. After the instructions on the law have been read to you, each side will have the opportunity to present oral argument. What is said in closing argument is not evidence. The arguments are designed to summarize and interpret the evidence. Since the state has the burden of proving the defendant guilty by proof beyond a reasonable doubt, the state has the right to open and close the arguments. After the arguments have been completed, you will then retire to deliberate upon your verdict. Again, let me remind you that until the case is submitted to you, do not talk to each other about it, about anyone who has anything to do with it, till the end of the case when you go to the jury room to decide upon your verdict. Do not talk with anyone else about the case or about anyone who has anything to do with it till the trial has ended and you've been discharged as jurors. Anyone else includes members of your family and your friends. You may tell them that you are a juror in a criminal case, but don't tell them anything else about it until after you have been discharged by myself. Do not let anyone talk to you about the case or about anyone who has anything to do with it. If someone should try to talk to you, please report that to me immediately by contacting Officer Hawks. Do not read any news stories or articles or listen to any radio or television reports about the case or about anyone who has anything to do with it. As jurors, you'll be given the opportunity to ask written questions of any of the witnesses called to testify in this case. You are not encouraged to ask large numbers of questions because that is the primary responsibility of counsel. Questions may be asked, but only in the following manner. After both lawyers have finished questioning the witness, and only at this time, if there are additional questions you would like to ask the witness, you may then seek permission to ask that witness a written question. Should you desire to ask a question, write your question down with your juror number on a full sheet of clean paper and raise your hand. All questions from juror must be factual in nature, designed to clarify information already presented. In addition, jurors must not place undue weight on the responses to their questions. The marshal will pick up your question, present it to the court. All questions must be directed to the witness and not to the lawyers or to the judge. After consulting with counsel, I would then determine if your question is legally proper. If I determine that your question may properly be asked, I will ask it. No adverse inference should be drawn if the court does not allow a particular question. The state of Nevada will be the first party that will call witnesses. When they call a witness, they have an opportunity to do direct. The defense can do cross. The state has a right to do redirect, and the defense has a right to do recross. So both sides have two opportunities to question the witness. When both sides are done questioning the witness, I'm going to turn to the witness. I'm going to thank them for being here, and I'm going to excuse them from their subpoena. If you have a question for that witness, I just ask that you get my attention at that time, because once I excuse a witness from their subpoena, I will not require them to come back to the courthouse to answer a written question by the jurors. So just raise your hand. I'll give you as much time as you need to write that question down. But for instance, if I excuse a witness today, I won't ask them to come back on Friday to answer any questions. Also, you have notebooks, the instructions that I have given you, as well as the procedure for asking written questions. They're also in the notebook if you have to refer to them at any time. Those are your juror notebooks. The only thing I ask is that they stay in the courtroom at all times until you go back to deliberate upon your verdict. At the end of the day, Officer Hawks is under court order. He will collect those notebooks. He will keep them in a safe place. He will not allow anyone access to your notebooks. So any notes you take will be kept strictly confidential. And then the next day when you come, your notebooks will be out on the chair for you. In the back, I think there's some paper for you to take notes. You're not required to take notes. It's just up to you. When you go back to deliberate upon your verdict, you will not have a transcript of the proceedings. So it will be your memory collectively as jurors, as well as your notes that will prevail during your deliberations. At this time, also your blue badges, please make sure you wear your blue badges at all times when you're in the courthouse. When you leave the courthouse, I don't care if you take it off, but that just identifies you as a juror in Department 12. So people in the courthouse, witnesses and persons involved in this case know not to say anything around you. So very important when you come in, make sure that blue badge is on. And at this time, the state of Nevada may address the jury panel in your opening statement.
Thank you very much, Your Honor. gentlemen. Again, my name is Michael Dickerson. My co-counsel is Melanie and Marland. We're prosecutors with the Clark County District Attorney's Office. And you're here for the case of State of Nevada versus Kim Blandino. At the heart of this case, this is about the rule of law. Now, the rule of law is something that is a concept, right? Something that was discussed by Dwight D. Eisenhower, the 34th President of the United States, who also was a 5-star general and the Supreme Allied Commander of the forces in Europe during World War II. He said about the rule of law that the clearest way to show what the rule of law means to us in everyday life is to recall what has happened when there is no rule of law. When you think about that, that is maybe experiences that you've had, things that you've heard from loved ones or family members, possibly time spent or escaping countries that are run by corruption and organized crime, or on the battlefields in a place where law does not exist. Here in the United States of America, in the state of Nevada, we are fortunate to live under the rule of law. Now, what is the rule of law? Generally, it's a concept which is usually used to distinguish a civilized, law-abiding world from barbarism and chaos. It's the principle that all persons, institutions, and entities are accountable to the laws, and that they're publicly enacted laws which are equally enforced and independently adjudicated. That's very important. The independently adjudicated part discusses the courts. The latter two, or the former two, discuss the legislature and the executive branch of our government. Here, what you're going to hear about is the courts. And when you think about the rule of law, if you think about it like a building, the courts and an independent judiciary are the foundation for our rule of law. Being able to decide controversies in these courts without undue influence is the most important thing that can occur to uphold our rule of law. Judicial independence is important because it guarantees that judges are free to decide honestly and impartially, in accordance with the laws and the evidence, without concern or fear of interference, control, or improper influence. Now, you may be thinking, okay, doesn't every case have to do with the rule of law? Yeah, sure. Doesn't every case have to do with courts? Of course, but this one directly. This begins August 28, 2018. The defendant, Mr. Blandino, who's seated right here in that red shirt, was there in the Las Vegas Municipal Court, there on a traffic ticket, several to be exact. The judge that day was Judge Pro Tem Michael Federico. During this particular court hearing on August 28, 2018, Mr. Federico heard the case against Mr. Blandino. So Judge Pro Tem Federico was the decider of the law and the fact there in that misdemeanor traffic citation trial. It's important to know what a Judge Pro Tem is. Mr. Federico is, as you'll hear, a full-time lawyer who is also appointed by the City Council to sit as an appointed judge in place of an elected judge when that judge is unavailable. When he's sitting as a Judge Pro Tem, as it's called, or an alternate judge, he has all the powers of any other judge that has that same jurisdiction. And here this day, he was exercising those powers. You'll hear about that case. You'll hear what happened. You'll hear that ultimately Judge Pro Tem Federico found Mr. Blandino guilty of the traffic offenses and also found him in contempt of court. Now, you'll hear that Mr. Blandino was not happy about that, which is fine. And there is recourse for that under the law. There's the ability to appeal, which exists within our system of justice and under our rule of law. To take that decision to another court, for another independent judiciary to take a look at it and make an impartial decision
based upon the law and the evidence. Well, Mr. Federico had no involvement after that point, as after August 28th, 2018, his role as a judge was done. But Mr. Blandino filed an appeal, as was his right. That appeal went to the district court, and ultimately in March of 2019, the district court denied and dismissed Mr. Blandino's appeal. But a month later, August 8th, 2019, Mr. Blandino decided that the next thing he was going to do was go to Judge Pro Tem Michael Federico's private law office, where he practices law as his regular job. There that day, he goes in and he talks to the receptionist that's there at the front, Ashley Williams. You're going to hear from her. He starts asking her probing questions, asking her to see Michael Federico, asking if he's in the building, seemingly just not wanting to leave. What's estimated as Mr. Blandino being there for approximately 20 minutes or so leads to Mr. Blandino saying, "Can I just write him a note?" Mr. Blandino writes this note to Judge Pro Tem Federico. And as you'll see, Mr. Blandino titles it up top with his name, his email address, and his phone number. Ashley Williams, the receptionist, date and time stamps it with their standard date and time stamps machine that's there at the front, April 8th, 2019 at approximately 10:31 a.m. Of note, Mr. Blandino entitles this note to Michael Federico as "To Michael Federico, Pro Tem Judge, City of Las Vegas, alternate judge." He's sending this note to Mr. Federico in his capacity as a judge. As you'll hear, that's the only involvement that they'd had with each other, and so that was the reason that Mr. Blandino was there. You'll see that in this particular note, Mr. Blandino writes, "I am ready to begin filing my complaint against you for your activities on the bench." He indicates that he's going to give Judge Pro Tem Federico an opportunity to negotiate a settlement and that he needs to do it within the next 10 days. Well, the next day, Judge Pro Tem Federico goes to the Las Vegas Metropolitan Police Department, files a police report. And at that point in time, the investigation begins, but that was the only event, and it was moving slowly. And Mr. Blandino had not heard anything from Judge Pro Tem Federico. So on April 25th, 2019, Mr. Blandino arrives here in this building, back in the Las Vegas Municipal Court, in a courtroom where Judge Pro Tem Michael Federico was sitting as a judge hearing cases. Now, Mr. Blandino was not on calendar to appear that day. He didn't have business before Judge Pro Tem Federico. And so, as a result, Judge Pro Tem Federico told Mr. Blandino, "You need to get out of here. You came to my private law office. That's not okay. You need to go." Mr. Blandino takes that as an opportunity to tell the judge, "No, I don't think that's correct. You're out of order," as he's pointing to him, but ultimately leaving the courtroom. Later on that same day, back at Mr. Federico's law office on 9950 West Cheyenne, way in the northwest part of town, far from downtown, Mr. Federico's back there doing work after he's completed his day as working as a judge. And he's working in his capacity as a private lawyer at the time, but again, Mr. Blandino hasn't had enough. He shows up to Mr. Federico's office again, and this time he has a prepared letter that he's typed up. This letter, again, entitled to Michael Federico in his capacity as a judge pro tempore from Kim Blandino. In the letter, Mr. Blandino elaborates. He says, I'm an investigative reporter and an unpaid volunteer investigator for the NCJD, which you'll hear is the Nevada Commission on Judicial Conduct. It's a public commission that was created by the Constitution of the state of Nevada and is operated and mandated to operate within the confines of the law. It also has special supervisory authority and investigative power over the courts. And they do, in fact, have investigators. You'll hear that their investigators, in fact, have a lot of power. Power to issue subpoenas, power to compel public employees to cooperate. Any public employee that comes in contact with the Nevada Commission on Judicial Discipline investigator is required by law to cooperate with their investigation. And then Mr. Blandino goes on that he is an unpaid volunteer investigator for the NCJD to investigate judicial misconduct and corruption. He says, I was there today, that same day, April 25th, 2019, in these joint capacities. As you have already committed misconduct, you have already at least, quote, one strike, unquote, against you. It was in this regard that I came to your publicly listed offices to see if I could meet you man to man and see if we could resolve my complaint with you without having to use scarce judicial resources and NCJD resources, as I have attempted to do with other misbehaving judges. And in fact, I do with whomever I have a complaint with. He goes on, so to avoid having the NCJD subject this complaint to their protocols, I once again reach out to you to resolve this matter between you and I, or your attorney if you wish to have an intermediary. Please repent of this tyranny that you yourself are a slave of, and stop this enmity that you have with reason, logic, and common sense that God gave to humans to guide us, as well as the light that he provides to guide our respective paths. He goes on, we should meet and see if these matters can be settled for all concerned and for a multitude of reasons as cited in part above. Please know that you will be judged as you have judged. If you continue on this path you are presently on, the judgment against you will certainly be very severe indeed. A judge's job is difficult enough for the best of persons. I implore you, for the sake of your soul, to consider what is in front of you if you continue down this dark path you are on, and the people you have undoubtedly hurt already. Quote, for what shall it profit a man if he shall gain the whole world and lose his own soul? Unquote. So, you've heard, as I told you a little bit about the Commission on Judicial Discipline, you're going to hear from the Executive Director and General Counsel for the State of Nevada's Commission on Judicial Discipline. That's going to be Paul Dyla. He'll tell you the defendant was not and never has been an investigator for the Nevada Commission on Judicial Discipline. This takes us to April 29th, 2019. After the events that occurred on the 25th, the investigation into this matter ramped up. Mr. Federico, you'll hear, was extremely concerned and worried about his own safety and the safety of his family. And as a result, detectives with an FBI task force got involved and were actively talking to Mr. Federico. On April 29, 2019, two of those FBI task force officers, Detective Kenneth Mead and Marshal Peter Marowitz, go to Mr. Federico's law office there at 9950 West Cheyenne. They meet with Mr. Federico, and after they've discussed the circumstances of this case with them, they say, well, do you feel comfortable if we are here and you call Mr. Blandino at the number he's provided you and just say
what's going on? What do you want? What's it gonna take to end this? So, there, in the deposition room at that law office, Mr. Federico with Detective Meade and Marshal Marwitz in the room called. They called the number that Mr. Blandino provided on all his paperwork, 702. And Mr. Blandino picks up. They recognize his voice. They know it's him. It's the same number he's provided. And the conversation lasts for approximately 21 minutes. During that time, Mr. Blandino kind of goes on some rants and is difficult to direct, but the one thing that is clear, when Mr. Federico asks him, what's it going to take to stop this? What is going on? What do you need? What do you want from a settlement? Mr. Blandino indicates that at minimum, he's going to want an apology, but he's really not sure. He's surprised that Mr. Federico had called him, and he is going to have to think about what he wants as far as his resolution to these matters. So, Mr. Blandino keeps pushing Mr. Federico to meet him in person. He really wanted to meet Mr. Federico in person. Obviously, for the apparent reasons, that was not going to happen. The task force officers involved in this case and Mr. Federico were not going to do that. So they confirmed. How about we communicate via email? Mr. Blandino confirms his email. It's the same email that he's provided here, kim43792@earthlink.net, and they exchange emails. That brings us to May 2nd, 2019. It's a Thursday. On that day, Mr. Blandino emails Judge Pro Tem Federico, subject draft of settlement agreement. Michael attached his proposed draft of settlement agreement. If acceptable, you can sign and I can get to your office same day or next day to sign same original. Let me know expeditiously. And attached to that email was this, what Mr. Blandino entitled Settlement Agreement and Release. You'll see that when we look at it, at the top, it lists the parties involved as Mr. Blandino's laid them out. He calls himself the complainant, Kim Blandino, identifying himself there as a volunteer unpaid investigator for the Commission on Judicial Discipline. He identifies Judge Pro Tem Federico as respondent. Michael Federico, alternate judge for Department 20, Courtroom 1C, Las Vegas Municipal Court at the Regional Justice Center. And in this settlement agreement that he's titled it, he asks for a number of things, and he tells Mr. Federico what he is willing to do or not do, for that matter, if Mr. Federico gives him these things. Namely, in consideration for the terms set forth herein, Mr. Blandino indicates that he will accept a $25 payment from Mr. Federico, which he indicates is because he's paid for jabs of prior hearings. Jabs, you'll hear, are video recordings of court hearings. So he indicates that Mr. Federico needs to pay him $25. He further indicates that Mr. Federico needs to complete a class, apologize in writing prior to May 30th, 2019 for ordering Mr. Blandino out of the courtroom on April 25th, 2019, within 10 seconds, as he says, under threat of being in contempt and put in jail, and acknowledge that Mr. Blandino has a right to observe court in the future unless proceedings are specifically sealed or closed to the public. So right now, he's indicated a $25 payment, an apology in writing. Additionally, Mr. Federico would be required to complete at his own personal expense the Ethics, Fairness, and Security in Your Courtroom and Community class in person in Reno in October of 2019, or alternatively, pay $500 to the Clark County Law Library and give a copy of any receipt to Mr. Blandino prior to October 31st, 2019. So there he has exactly what Mr. Blandino wants. $25, a written apology, Mr. Federico to take a class in Reno at his own expense, as well as to, or alternatively, pay $500 to the Clark County Law Library. So what is it that Mr. Blandino indicates that he's willing to give for this? Well, he indicates here that he's willing to give up anything, including any of these suits, really, including any complaints to the Nevada Commission on Judicial Discipline. It indicates further that complainant covenant and agrees. So Mr. Blandino agrees that he has not and shall not bring any other action, claim, or suit or proceeding against anyone, Michael Federico, in any capacity, either individually or in his official capacity, for any activities on or after April 25th, 2019, including filing any complaints to the Nevada Commission on Judicial Discipline. Further, complainant agrees that he will withdraw and otherwise voluntarily dismiss a customer feedback complaint that he had lodged and attached as an exhibit with the court, the municipal court. It further indicates within this document that should Mr. Federico die, what would happen with the monies that were to be paid. It indicates should Mr. Federico's death occur prior to the payment for the above mentioned course or the Clark County Law Library, then Mr. Blandino would be entitled by this provision to the payment that would otherwise have been paid to the Nevada Judicial College for tuition from the estate of Mr. Federico. And it goes on. The settling parties acknowledge that this agreement represents a good faith settlement of the issues of April 25th, 2019. That this agreement is intended to bar any complaint against the respondent by a complainant with the Nevada Commission on Judicial Discipline or any court. So it's intended to bar any complaint. So it's saying that Mr. Blandino will not file any complaint against Judge Pro Tem Michael Federico or any other with the Nevada Commission on Judicial Discipline or any other board or agency. Now, a day goes by, May 3rd, 2019. Another email comes in from Mr. Blandino to Mr. Federico. Mr. Federico had not responded at this point. This is under the same email chain, but now is titled under the subject, Forgot to Attach Exhibits to Prior Email. And there's an attachment, the proposed settlement with exhibits. Now this is where I had mentioned that you saw before, there's the customer feedback complaint that he said that he attached as an exhibit. Well, he forgot to, but he attached it here the next day. He also attached a copy of the handwritten note that he dropped off at Judge Pro Tem Federico's private law office on the 8th of April, as well as the letter that he dropped off on the 25th of April at the law office. Now, on May 9th, 2019, Mr. Federico emails Mr. Blandino back. He says, please provide a new proposed global agreement that would cover anything in the past you believe negative against me so that I can see it. Your current proposed agreement does not resolve everything you seem to be complaining about, and I need better explanation of what you will attempt to do if I do not agree to your demands. I need to know exactly what you are asking for in exchange for resolving all your purported, quote, issues, unquote, so that I can have it in writing to review. This is large part of reference this ongoing investigation and the settlement, the quote-unquote settlement agreement that Mr. Blandino had provided, which indicated that most of what he was not going to complain about if he got what he wanted were the events of April 25th, 2019, but we know that they had that original interaction in August of 2018. Mr. Blandino responds very shortly thereafter. Michael, here is a letter that I was just about to send to you before I read your email. I think it covers some of your concerns. I must be leaving very shortly, yet, so I am not spinning my wheels, I do need to know if a written apology and the Judicial College course / law library donation is a, quote, bridge too far, unquote, for you as it stands. I now have the jabs, and I am ordering a transcript. What I am asking for is consistent with remedial action the Nevada Commission on Judicial Discipline has effectuated over decades. I am writing to be flexible and reasonable. Yet if the things I propose are a non-starter for you, I do not want to move forward down a dead end. Kim Blandino. He attached a letter to this email. The letter notably was dated up top as May 8th, 2019, though it was emailed on May 9th, 2019. You'll see that it was dated on the end of the document, May 9th, 2019, which would appear to be consistent with what Mr. Blandino indicated, that he'd been writing this letter for some time. There in that letter, again, addressed to Michael Federico in his capacity as a judge pro tempore, Mr. Blandino states, I have not received any word back from you regarding the proposed settlement offer. I spent a great deal of very valuable time preparing that document. I have so very much work to do already as a result of judicial violations. I will need an answer or for you to otherwise respond to this proposed settlement on or before May 23rd, 2019. Mr. Blandino goes on, I have extended a good faith offer for something very serious. You, under threat of contempt in jail, ordered me out of a public courtroom because I came to your office to offer settlement. I have read nearly every case on the, quote, awesome summary contempt power, unquote, and the various law journal articles pertinent to summary contempt. This power can be and is abused. Even the wrongful threat of contempt can be abused. This is what you did. By you doing so, you violated important civil rights. In fact, you could be criminally prosecuted for a misdemeanor violation of federal civil rights under 18 U.S.C. section 242 for your actions on April 25th, 2019. He goes on, I have already told you that if we cannot settle this matter, I will file a complaint with the Nevada Commission on Judicial Discipline. This must be done to protect other people in the future. Of section 242, title 18, which Mr. Blandino referenced before as a federal crime, which Kim was told would be investigated. If we cannot come to a settlement, I believe it would be proper to go to the FBI with a criminal complaint against you for stopping me from observing you on the bench on April 25th, 2019. Granted, this would only be a misdemeanor. However, it may help others that come after me should you not agree to the apology and settlement. Additionally, Mr. Blandino goes on, I've come to realize that since you work with a partnership titled Olson, Cannon, Gormley, Angulo, and Stabersky, that I should give some notice to these individuals of the matters involved prior to filing with the Nevada Commission on Judicial Discipline or the FBI. That's Olson, Cannon, Gormley, Angulo, and Stabersky was the law firm where Mr. Federico had practiced law as an attorney privately, aside from his work as a federal judge, the same one that Mr. Blandino had been going to over this time period, the same one that the calls have been placed from. Mr. Blandino goes on talking about why he should do that. The calculus for this is simple. Putting myself in the place of any one of these partners and everything else being equal, I would want to know that a person who worked with the firm and had a prominent web page was not bringing any disrepute in any way to the firm or its name. Olson, Cannon, Gormley, Angulo, and Stabersky has been in existence since 1960. It would not be fair or Christian of me not to inform the firm of the issues at hand if we cannot resolve them. Therefore, Mr. Blandino says, consistent with my beliefs, I will send a copy of all relevant documents to the firm unless I hear from you by Monday, May 15, 2019. You've heard a lot of these so far. You must, unless. Ladies and gentlemen, that's what we're looking out for in this case. That's what this is. That's what extortion is. You must do this, or I will do this. I will accuse you of a crime. I will subject you to disgrace. That is extortion. Well, as he indicated, the deadline, if Mr. Blandino did not hear from Judge Pro Tem Michael Federico, was May 15, 2019. That came and went, and on May 16, 2019, Mr. Blandino sent an email to all of the managing partners, the executive board of Mr. Federico's private law firm. Jim Olson, Walt Cannon, John Gormley, Peter Angulo, Mike Staberski, and included on there was Michael Federico. Mr. Blandino writes, as the subject proposed settlement issues, please see the 3 attachments for review. Leaves his name, same phone number that he's been using. And he writes a new letter. This letter is entitled To the Firm, to the managing partners of this firm, and copying Mr. Federico. Here in this letter, he also attaches his original April 8th, 2019 note that he wrote in their front lobby. He also attaches their the April 25th, 2019 letter he dropped off to that law firm for Mr. Federico. He also attaches that what he called a settlement agreement, which is an extortion document, to this particular letter to the firm, and his further extortion document of May 9th, 2019, which is dated at the top, May 8th, 2019, that we just went through. With all these documents, there were additional exhibits that he had included, and he'd included all those here as well. The investigation continued. Task force officers of the FBI ultimately served a search warrant at Mr. Blandino's home. Here in his room/office, they find his, what would be a command center, and there's a multitude of evidence, including case file that he had for Federico, a copy of his extortion document, and then it brings it back. Ladies and gentlemen, this is about the rule of law. Judicial independence is important. And it's important to us because it guarantees that judges are free to decide honestly and impartially in accordance with the law and evidence, without concern or fear of interference, control, or improper influence from anyone. And that's why we're here. That's why Mr. Blandino is charged with extortion for all of these events that have been detailed. And that's why Mr. Blandino is charged with impersonating a public officer for holding himself out to be an investigator for the Nevada Commission on Judicial Discipline, which he is not. And as a result, at the end of this trial, Ms. Marland and I will come back and ask you to return a verdict of guilty on both counts, extortion and impersonation of a public officer. Thank you.
Thank you, Mr. Bateman. At this time, ladies and gentlemen, we're going to take about a 5-minute recess. During this recess, You are admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication, or social media. Read, watch, or listen to any news or media accounts or commentary about the case, or doing your research such as consulting dictionaries, using the internet, or using reference materials, make any investigation, test a theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you, and Officer Hawks will let you know when we're ready.
Thank you. All right, transition jury. Jurors, please leave your notebooks on your chair. Please come to order. Court is now back in session.
Bateman, you're ready?
Yes, before we bring the jury in, I would like to make a record if I could.
Sure. The record will reflect that the hearing is taking place outside the presence
Thank
of
you.
the jury panel. Go ahead.
Yeah, Judge, it just has to do with, previously during the jury selection process, and Mr. Blandino wearing the, shirt that's been photographed and entered in the record. After court, we met in my office briefly yesterday, whenever that was, 5:30, 6 o'clock. There were some questions that he wanted me to ask, and samples that he wanted me to ask that, were not entirely appropriate. There were ways to get some of the information that he wanted, and I explained that to him. But one of the things he said was that he was going to wear his shirt. I advised him, it
Not
was a
to.
bad idea.
Yeah.
I told him, look, I can't stop him. And so I just want that on the record. Personally, I don't, I know that he does not want me trying this case. He wants to do this. I think this is some sort of tactics to get in sort of the things that he wants and sort of direct this and get issues brought before. That's my opinion, and I just want that on the record. I told him it was a bad idea to wear this shirt.
Okay. All right, and we can bring the jury panel in now? You can bring him in, Officer
Oh,
Hawks.
okay. Okay, he did inform me he intends to wear a suit or change after
Okay.
lunch. Just now.
Wasn't that a business? Thank you. Everyone, please be seated.
Does the state stipulate to the presence
You do.
and the defense?
Yes, Your Honor.
Mr. Bateman, you may address the jury panel in your opening statement.
Thank you. Great. Yeah? Can you hear me? Okay. All right. Thank you, ladies and gentlemen of the jury. You see up here the word quixotic. Maybe you've heard of it. I'll tell you that Mr. Blandino is quixotic, right? What? What does that word mean, right? Here's the definition. It's sort of foolishly impractical, especially in the pursuit of ideals, right? It's used for someone that's sort of innocently idealistic, possessed with some sort of romantic optimism. Comes from Don Quixote. Maybe you read Don Quixote in school. I remember I had to read it, and the first modern novel, they call it one of the foundations of Western literature. And who was Don Quixote? Don Quixote was an hidalgo, which was the lowest class of Spanish noblemen, right? But he read tales of chivalry. He read tales so much so that he became, inspired. And he decides to take a squire on his horse and sort of restore honor, restore chivalry back to Spain, right? He wants to sort of help make the world as it should be, to bring back this kind of accountability. And he sees as, his adventures proceed, there's not many opportunities. People think that he's crazy. They say, look, it's a noble what you're doing, but, it's a little bit crazy. He is this sort of dreamer, right? He's this misunderstood. He gets laughed to scorn, right? So he's routinely mocked and scorned, but he never ever lacked sincerity in what he was trying to do. Okay, he was always sincere, and if you remember from the book, he thinks that the expression "tilting at windmills" comes from this book. He sees these windmills as sort of giant invading armies that he has to protect against. He has a battle with a flock of sheep that he thinks is also an invading army. His helmet is a basin that someone's barber's basin that they were washing out, and he's sort of reclaiming it from this thief. And despite being thought of as sort of, like I say, as being crazy, he was always sincere in his quest. Now you've heard some things about Mr. Blandino, how he brought it about, but in many instances, he is sincere. The quote here from Don Quixote here, when we told him that he's mad, okay, is that maybe the greatest madness is to see life as it is, rather than what it could be. Okay? And you'll see that Mr. Blandino, okay, is committed to bringing accountability to the judiciary here in Clark County. That not only do we have to obey the law, we have to obey the rules, but so do judges. Okay? And much like Don Quixote, you might disagree with the manner in which he goes about his quest, right? And that's fine. But what I want you to always think about during this trial is, what is it that Mr. Blandino wants? You'll see in this, you'll have, the letter, it sort of cherry-picked parts out of that letter. You'll have the whole letter. You'll be able to review it. You can see Mr. Blandino really wants nothing for himself. He wants to hold the judiciary to account. You saw he was kicked out of the courtroom on April 25th of 2019. Now our courtrooms are open forums. They are open to the public. We're not living in North Korea or the Soviet Union. We allow people to come in. We have a camera in the courtroom. We have people here observing. This is open to the public because we don't do things here in secret. And so when he gets kicked out, he goes to, you heard it, he goes to Mr. Federico. And you'll see that Mr. Federico, or you heard from on the opening statement, and the testimony will play out, that Mr. Federico was told what to say. He had, these detectives that were mentioned, they're telling him, hey, say this, say this. You saw that Mr. Blandino really just wanted to meet with him. Just, as he said, let's just meet. And really just wanted to apologize, just sort of talk it out. It's like, no. It's something in writing. No. Have him write what he wants. You heard, he was surprised, They want to tell you he's this terrible, crazy, evil extortionist, but, he gets called up. What do you want? Oh, gee, I don't know. Can we meet? No. I want something to write down. No. Doesn't even know. Well, give me a couple of days. So he writes him. It wasn't sufficient to arrest him. Otherwise, they probably would have. Think about that. Use your common sense. It was insufficient. So, he's thinking that Mr. Federico wants to, wants to work something out, wants to be, that Mr. Federico is sincere and trying to work something out with him, and just say, okay, what is it? Can we just, shake hands, break bread, that sort of thing. And so he follows up. They follow up with it, okay? With the, what is it you want? Don't you want more? You saw the letter that Mr. Federico said to him. It's like, wait, tell me more. Don't you want more? Because they're trying they're inducing him into this trap here, okay? Think about this, and I asked you to write down, what does Mr. Blandino want? Okay? He really wants nothing for himself, okay? And, when he talks about this, is a bridge too far? Well, it's negotiation. There's a give and take. Hey, all I have to say is no. No, I don't want that. No, I'm not going to do this. And you've heard also in opening statement that we'll hear from Paul Dyla, who is the, I believe his title is Executive Director of the Nevada Commission on Judicial Discipline. Okay? He will tell you that Mr. Blandino is within his right to observe court and to submit complaints to the Commission on Judicial Discipline. Anyone from fellow judges, attorneys, general public, anyone who sees misconduct on the part of a judge is perfectly within their right to submit a complaint to the Nevada Commission on Judicial Discipline. In fact, that's how their work gets started, and you'll hear more about that process. And that's what Mr. Blandino, it's really what his quest is. You'll hear from him. You'll hear about his history of observing court, of submitting those complaints to the commission. And as you do, again, I want you to bear in mind, what is it that he wants? What is it that he wants? You'll see, he's really, again, not asking anything for himself. And they won't be able, really, to, they have a high burden in proving this, okay? Is because one of these essential ingredients here in extortion, okay, is the intent to extort money, influence the action by certain means. But he doesn't want really anything for himself. And I think as as the witnesses come and they testify, I want you to keep that in mind. And then as he testifies, you'll hear from him and understand the sincerity that he brings to this. That he is a deeply religious man, and part of this desire to just go, to reconcile, to apologize, comes from, there's a scripture in the Bible where you agree quickly with an adversary while sour in the way. I believe it's in Matthew chapter 5. And that's part of really what is motivating him here in seeking to talk to Mr. Federico. And but you'll see that they're really just playing him for a chump. They keep asking him for more and more, just to try and lay that trap for him. And the intent really won't be there. You'll also hear about, you'll have the letters. And in there, you said, addressing his, calling himself an unpaid volunteer investigator. You can draw the inference, an unpaid volunteer is not official. He's not an attorney. He's not as sophisticated, again. He might be, yes, tilting at windmills, but he is very sincere in his quest to bring accountability, to hold judges to account. And he'll expound on that more later. So again, as I ask you to keep an open mind as you hear it, again, I asked you to separate how you might feel about him and just look at what the facts are. You'll have those letters in their entirety, in their context, and just remember, what exactly is it that he wants? And I think once you see that, you'll realize they haven't meant their word. He had no intention to extort, no intention to do any of the things that he is accused of. And so I appreciate your service, and I appreciate you being willing to keep an open mind.
Thank you very much, and state your call the first witness.
The state calls Ashley Williams.
solemnly swear that the testimony you're about to give in this action will be the truth, the whole truth, and nothing but the truth, so help you God. You may be seated. Please state and spell your first and last name for the record.
Ashley Williams, Ashley Williams. Good morning, ma'am. I'd like to draw your attention to April of 2019. Were you working at the time?
Yes, I was.
Where were you working?
I worked at Olson, Cannon, Gormley, Levinsky Law Firms.
And Silver Sheet?
Yes.
And where is that located?
That is located at 9950 Cheyenne, I believe. I'm sorry, I don't work there anymore.
Would that be 9950 West Cheyenne?
Yes.
Is that here in Clark County, Nevada?
Yes.
And when did you start working there?
I believe I started work there maybe April 7th or 6th.
Okay. And what was the nature of your job duty?
I was hired as a law clerk, sorry. I was hired as a file clerk.
Okay. And part of being file clerk, what does that entail?
It was just filing papers and typing the files, the correct files.
And were you ever expected to interact with any visitors or clients?
No, I was told I was to be working upstairs, not talking to anyone except for the attorneys.
And on April 8th, 2019, did you have to interact with anyone?
Yes, I actually, the day before, I was called into an office saying that the receptionist downstairs had to quit because of an emergency leave, so I had to be working downstairs as of the next day.
So within the first week of this job as a file clerk, you had to be a receptionist as well?
Yes.
And on April 8th of 2019, did anyone who was present here in the courtroom come into the office in 9950 West Cheyenne?
Oh, yes.
And could you point to that person and identify them by his
That
equipment
was
or wearing?
in a red shirt and gray pants.
May the record reflect
So
identification.
reflected.
And what time did this person come in?
Roughly around maybe 9:50-ish, 10 a.m.
What time had you started your day?
Oh, I am supposed to get there at 7:50 to open.
So at approximately 9:50 a.m., what first drew your attention to someone coming into the office?
So our office windows are on the left side of me facing this way. So I literally see everyone that comes up, that drives up to that is going to come to our office.
Is there a parking lot right outside those windows?
Yes.
And so did you see someone drive up?
Yes, I see a white pickup truck.
And did you see the individual you identified as the defendant step out of that truck at some point?
I did not see his face until he came inside.
Okay, and once you came inside, what happened?
He came up to a window kind of like this and asked if he can speak to Michael Federico.
Okay, did he identify himself?
I'm not 100% sure if it was right away, like I'm, so-and-so.
Fair
I'd
enough.
like to speak to Michael Federico.
At some point, did the defendant identify himself?
Yes.
And who did he identify himself as?
Kim Blandino.
And you mentioned he had asked for Michael Federico?
Yes.
What was your response to that?
I said, give me 1 second, let me see if it's in.
Okay. Were you able to get a hold of Mr. Federico at that time?
I was not able
And did you inform the defendant of that fact?
Yes.
What was his response?
He asked if he could write a letter,
And,
and I gave him a piece of paper and a pen and proceed.
okay, and how long did he write the letter for?
Roughly like 20 minutes or so.
Was there any,
25.
was there any discussion while he was writing the letter?
Oh, yes, we were conversing as he was writing the letter.
Okay, do you recall what type of conversation you had?
He was pretty much just asking questions, just random little questions like, how are you, how long have you been working here, if I knew Michael Federico was a judge.
Okay. Did you know that Mr. Federico was a judge?
No, I did not. At that time, I did not. I was brand new.
Okay. And did Mr. Blandino ask you anything further about Mr. Federico's location?
He just asked if he was in office. And I said, I'm not 100% sure because I don't know what car he drives.
Did Mr. Blandino ask you to go look for Mr. Federico?
He did, if I was able to go look for him.
Were you able to do so?
I could not because I was the only person on the first floor, pretty much.
Part of your job duty?
Yes,
was
I
to-
cannot leave.
Okay. And I'm just gonna ask that you let me finish my question, just so we're not talking over each
Oh, okay.
other. Thank you. So the defendant was asking you questions as he was writing the letter, as
Yes.
we indicated. And did he ask for any further paper products?
Just there were sticky notes, literally you could see them, so he just asked for sticky notes.
So essentially a Post-it?
Yeah.
And I'm going to. I'm going to show you what's been marked as State's Proposed Exhibit 2, if I may approach. And do you recognize this?
Oh, yes.
Would you recognize this to be?
The letter that Tim wrote to Michael Federico to me.
Okay, is this, and when you say Kim, do you mean Mr. Blandino?
Yes.
Okay, and does this appear to be a fair and accurate, well, does this appear to be the actual piece of paper you provided Mr. Blandino to write the letter on?
Yes, because we had to stamp everything that came into the office, so I stamped it.
Okay. Do you want to move to the next proposed exhibit 2?
And it's A and B, you're
A and B, yes.
Okay.
Well,
Sorry, Judge, I'm gonna be this clear, it's 2A, and 2B, it's an envelope of paper and a sticky note.
2A and 2B. Any objection?
I'm seeing it, but I
It's
don't
just,
Go ahead.
anticipate an objection. So, okay. So the Post-it note is to be, okay.
Any objection?
No.
Okay, if they're admitted.
and, well, just going back to this 2B, is this on top of it, is that the sticky note you also provided Mr. Blandino with?
Yes.
Right. And if I may publish,
You may.
thank you. And so you indicated that you dated and timestamped all documents that come through.
Yeah.
And so you indicated that that chop right there, that was the timestamp that you had stamped on that piece of paper?
Yes.
Okay. And what was the date and time?
April 8th, 2019, 10:31 a.m.
And that Post-it on it would be the Post-it that was affixed on the piece of paper by Mr. Blandino?
Yes.
At some point, did Mr. Blandino stay or did he eventually leave?
He did eventually.
Did you ask him to leave?
No.
Were you comfortable asking him to leave?
So, as you guys know, I was new at that job. I was not supposed to talk to anyone. So yes, I was not comfortable with saying that. I was definitely nervous, just because I was new.
And eventually, did you see the defendant leave the Oval Office?
Yes,
And did you see him get back into his car?
yes,
Did you see what car he got into?
yes, the white pickup.
Did you ever come into contact with Mr. Blandino after April 8th of 2019?
No, I did not. That was him.
And did you provide this document, this piece of paper that posted to Mr. Federico when
I
you
did.
next saw him?
I did.
Did you ever come into contact with Mr. Federico before April 8th?
I did as a tour to meet all the attorneys when I first started.
Right, so were you aware that Mr. Federico was an attorney with the firm?
Yes, I was.
And just going back to the questions that were being asked to you as Mr. Blandino was writing this letter, you mentioned he'd asked you how long you worked there and whether you knew Mr.
If
Federico?
he was a judge, yes.
And you mentioned you did not know.
Yes.
Did he ask you any further questions about your own life?
I mean, it was just maybe like, if I had kids, he actually asked me if I had kids, and not really, not really things that I can actually remember. It was just a random conversation.
Did Mr. Blandino ask you any further questions about whether you had ever worked with Mr. Federico?
Oh, yes, he did.
Do you recall the substance of that question?
He asked if I worked with him on any other cases, and I proceeded to tell him I was still new, so I did not work at all with him.
Thank you. Court's indulgence. I have no further questions for this witness.
Cross-examination.
Mr. Summers? So you said, he was just asking a question, it was just sort of like small talk?
Yeah.
I guess.
We were just conversing.
Okay, so nothing that is so, I don't know, remarkable that you would remember specifically?
Just, if he asked if I knew Michael Federico was a judge, that was pretty much kind of the only, like, actual question.
And did he ask you for a copy of that letter that you?
He might have. There's people that do that, and we do have a copy machine right there, but I can't be I can't say 100% sure that I gave him a copy, because I do not remember, I'm sorry.
Okay, I have no more questions.
Any redirect?
Briefly, Your Honor.
Yeah.
Ms. Williams, while Mr. Blandino was asking you these questions, did it appear to you as though he was there for longer than necessary to write what was essentially a one-page letter?
Oh, yes. I mean, he was probably there for 20 minutes, so.
And what was your sentiment during this whole interaction?
I mean, I didn't really think anything of it.
Do you recall if Mr. Blandino was looking around while he was writing the letter?
I'm sorry, I couldn't tell you. It was 3 years ago.
And fair to say, had you ever had to work as a receptionist after that day?
After that day, yes, I actually had to, they couldn't find anyone, so I had to be their permanent receptionist.
And would you say that based on your work after that, was it usual type of behavior to interact with someone for that long?
Oh, no, usually, I mean, when clients would come in, they would, ask if someone was there, and if they weren't, they kind of just left, or, hey, can you just let them know I was here, and then kind of just leave.
Fair to say they wouldn't,
Email them.
fair to say they wouldn't stick around for 20 minutes?
Oh, no.
No further questions?
Any response?
No.
Thank you very much for your testimony here today. You may step down. You are excused from this subpoena. Thank you very much. Okay, at this time, we're going to recess for lunch. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in the way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. Read, watch, or listen to any news or media accounts or commentary about the case. Do any research. such as consulting dictionaries, using the internet, or using reference materials, make any investigation, test a theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case, or form or express any opinion regarding the case, till it's finally submitted to you, will be in recess till 2 o'clock.
Thank you. All rise for next hearing, jury, please adjourn.
Please come to order. Court is now in session.
Stipulation order now or no?
Yeah. So,
Okay, the record reflects the hearings taking place outside the presence of the jury panel.
thank you, Your Honor. Mike Dickerson on behalf of the state. After consulting with defense counsel on the exhibits, defense has had an opportunity to review all the exhibits. We're looking at currently 1 through 34.
Okay,
At this point in time, we're going to enter a stipulation to the admission of these exhibits.
is that correct, Mr. Bateman?
That is correct.
Okay, so 1 through 34 are admitted at this time. Can the panel come in?
All right.
Jury, jury, oh, hang on.
No, that's okay.
You good? Okay.
You guys are done, right? Does the state stipulate to the presence of the jury panel?
We do, Your Honor.
Thank you, everyone. Please be seated.
Yes, Your Honor.
Stephen Babb, you may call your next witness.
Thank you. This one, Michael Federico.
You do solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. Please state and spell your first and last name for the record.
Michael Federico, Federico, first name Michael.
May I proceed, Your Honor? Thank you very much. Mr. Federico, what do you do for a living?
Primarily, I'm an attorney, and I'm also a fill-in judge in a few other judicial capacities.
Okay. How long have you been an attorney?
Since 1996,
And you're barred and licensed?
yes,
Where are you barred and licensed?
in Nevada.
Okay. And at what point in time, you had indicated that you're a fill-in judge or an alternate judge. When did you start doing that?
My first 2-year term for Las Vegas Justice Court was in 2001, quite some time ago, and it's a 2-year term.
Okay. And so that's Las Vegas Justice Court, is that right?
That's correct. That also, I've been called, not too frequently though, for Henderson, so it seemed like it carried over to Henderson too, because I made that long drive for someone in the past.
Okay. How about with the city of Las Vegas? Were you or have you been alternate judge there?
Yes,
Okay, and is that called the municipal court?
I believe the certificate that you receive, and it's an annual position, is an alternate municipal court judge.
Okay. So these positions as an alternate judge for the Justice Court of Las Vegas, the Justice Court of Henderson, as well as the City of Las Vegas Municipal Court, are these also known as positions of Judge Pro Tempore or Judge Pro Tem?
Yes, there's different types of titles you can have. Judge Pro Tem is kind of what we go by, but Judge Pro Tempore is also another term. I tell people, when they ask, I just say more like a substitute teacher, substitute judge.
Okay. Except a substitute teacher isn't appointed by the legislative body of the government, right?
That's probably true.
And you, as a municipal court Judge Pro Tem, would be.
Yes, through the Clark County Board of Commissioners and the Las Vegas City Council. Those are the ones that actually give the final approval to the list of names of who would sit.
So, if I have this correct, the judges in those courts that you've mentioned, and specifically here as it relates to this case for the Las Vegas Municipal Court, the full-time regular judges, are those judges elected?
Yes, sometimes they're originally appointed, but for the most part, they're elected to serve for the public.
But you, as an alternate judge or Judge Pro Tempore, are appointed to fill in when one of those judges is unavailable?
Solely appointed.
Okay. And when you're acting in your capacity as a Judge Pro Tempore, for the Las Vegas Municipal Court, what do you do?
Pretty much assume all the roles that a judge would be assigned, whoever you're sitting for. For example, maybe setting bail, not so much anymore, but there's bail, there's preliminary hearings, there's initial arraignments, hearing motions to release defendants from in custody. There's a lot of different things, and on top of that, in Justice Court, there's also civil litigation for the smaller civil cases where people are suing each other. You hear those as well.
And so you've been doing this since 2001, is that right?
For the most part, there was a period of time I was out of the state and I didn't apply for it. But every time that I applied for these positions, I was appointed.
Okay. And for the city specifically since approximately 2003?
That's correct.
And in 2018 and 2019, were you serving as a judge pro tempore for the city of Las Vegas Municipal Court?
Yes.
And in that capacity, are you sitting, wearing a robe and hearing trials?
Yes.
And so those trials in the Las Vegas Municipal Court, are those all misdemeanor trials?
Yes.
And frequently, I would imagine, traffic trials?
They're misdemeanor cases, and then there's they started up with just a traffic court where you only had traffic matters. Before, years ago, each judge would hear everything, and now they have a traffic commissioner that just hears traffic. So yes, traffic too, and I don't know what you would categorize it, but.
Okay. Now, those trials are decided solely by the judge, is that right?
Yes, it's a bench, each one's a bench trial.
Okay, a bench trial being different than a jury trial like this that we're in today.
Yes, the judge makes the ruling is guilty or not guilty, and then also makes determines the sentence. And
Okay.
imposes it, as opposed to the jury, which does all those things.
And the sentences that you impose for these various misdemeanors and traffic offenses can include jail time?
Yes, and misdemeanors, each misdemeanor that somebody's convicted or pleads guilty to can to 6 months in jail. So sometimes people will have 2 or 3 that are pleading guilty, and there's maybe like 3 consecutive sentences of 6 months that are stayed or whatever have you. Probably
Okay.
too complicated.
Okay. And so there's, when you say stayed sentences, is that kind of an indication of some sort of a probationary term of sorts?
Yes,
Okay. These punishments in the Las Vegas Municipal Court can also include fines, is that right?
fines, counseling, community service, and of course jail time, which is the most severe in my eyes.
And so as you sit there as a municipal judge pro tem, you have the power and authority by law to enforce all of that and hand down all those punishments.
All of those, and also administer the court to make sure everybody's in line, and so you also have contempt powers.
So you have the power to compel obedience to your lawful orders as well.
You try, but fortunately you have armed marshals that really are, in my eyes, are the people that can enforce things.
Okay. Now, as we get into looking at your work as a judge pro tempore, can you just describe for the ladies and gentlemen of the jury what a normal day in the Las Vegas Municipal Court as a judge pro tempore sitting on, say, the traffic calendar would look like?
Traffic calendar, you walk into court, and sometimes, depending if it's the county or the city and what day it is, you can have 100 people in the gallery. In other words, everybody waiting for their tickets. And so you sit down, and the clerk starts handing you stacks, sometimes like this, and you start going through them, calling the names, asking as far as what the charges are, seeing if there's some kind of negotiation, hear what the sentence would be, and then either it's usually guilty, not guilty, set it for trial. You just go through a wave of those. Those are usually the typical mornings in the traffic court. It's a big wave of people.
And so you said 100 or upwards of 100?
It could be a lot more. I don't want to speculate. All I can say is the gallery is usually bigger than this, and they're deep courtrooms, and sometimes they're pretty full.
And so you're just
Sometimes.
So you're
Especially
just
after a holiday. I'm sorry.
You're just calling case, adjudicating the case, going to the next case, adjudicating the next case, and so on and so forth until you finish the calendar for the day?
That's correct. You have a calendar that you are in charge of, and you need to kind of roll it along so you can get everybody who spent their day sitting in court, and get them out there and back to their lives and get them out of court.
Okay. And on that same calendar would be those traffic trials you discussed.
That's correct. Trials would go later on in the day, usually, or in the morning, just because the trial takes up a lot of time sometimes. What I mean by that is a lot of cases will take anywhere from 30 seconds to a few minutes to complete or adjudicate, but a trial could take at least 10 minutes, and sometimes it could take a few hours, and in other courts, it could take longer.
Okay. And that kind of depends on the charge itself?
Yes, in traffic court, they're usually not too complicated, and they're pretty fast, but if you're in justice court and you're hearing, for example, a murder trial, it could be a preliminary, not a trial, but a preliminary hearing, that could take 2 days,
Okay.
or even longer.
And a preliminary hearing is something totally different than handling a misdemeanor case, is that right?
Yes,
Okay. That's like an initial hearing on a felony to determine whether it's gonna come up to the district court for a jury trial?
yeah, it's almost like almost like a practice trial to get information, so that they can go on to this level court.
And that's something that you would hear in your capacity as a judge pro tempore for the justice court?
Countless,
Okay.
over the last 20 years.
So I want to direct your attention to August 28, 2018. Do you remember that day?
Yes, not the whole day, but I remember certain parts.
Specifically a part where you were working in your capacity as a judge pro tempore for the Las Vegas Municipal Court.
Yes,
And in that capacity, do you recall what court you were working?
I believe it was traffic.
Okay. And did you have a particular defendant in one of those traffic cases that you actually see here in the courtroom today?
Yes.
If you could, please point to that individual, identify a piece of clothing that they're wearing.
Gentleman with the three-piece suit and the large red, I think it's a tie, I'm not sure what it is.
An ascot.
Yeah.
Okay, he corrected me. It's an ascot. If the record will reflect the identification of the defendant, Your Honor.
So reflected.
And do you know the defendant's name?
I believe it's Kim Dennis Blandino.
Okay. And is that a name that you've become familiar since August 28, 2018?
Unfortunately, yes.
Had you ever known Kim Blandino before August 28, 2018?
No clue who he was. He was just somebody else that I had to hear a case for.
And now, you have your morning calendar that day, is that right?
I don't recall the calendar. I mean, I've done probably over 500 calendars, but there was a calendar.
Okay. And is that because the case that really sticks out is Mr. Blandino's case?
That's correct.
So at some point in time during that calendar that you're working as a judge, can you tell us about what happens with Mr. Blandino?
Can you be a little bit more specific?
Yeah, if you could just tell us like how he comes before the court, how you end up calling his case, any of that, just generally.
Well, I mean, generally speaking, you call the case, ask both sides if they're ready to proceed, and then you proceed, you hear the trial, just like you see on TV, and at the end, there's a ruling. In this case, it was quite different than the normal trial. Sometimes as a judge, you can hear several of these types of trials in one sitting. You can have a trial, 20 minutes later, another trial. They all pretty much run the same way. And this one was highly unusual. You could see it was a very argumentative defendant, didn't want to cooperate. He thought everything revolved around him. He had to be warned several times to basically cut it out. You know, I know the way things work. We're going to do things the way they're supposed to go. And, you know, he just really couldn't comply, at least at the beginning. It was continuously saying things under false pretenses.
So this particular traffic trial sounds like it was unusual?
It was difficult.
Was it outside the norm of the normal traffic trials that you handle?
It was way on one end of the bell curve, so to speak. It was one of those outliers. It's nothing like you normally would expect.
So yes, it was.
Yes.
And with that as well, was it because of the traffic citations themselves, like the actual charges that made it different?
No,
What was it that made it so odd and on the other end of the bell curve?
it was the defendant who was representing himself.
Okay. Now, this particular trial and the events surrounding it, were those captured on video and audio recording?
I believe so, yes.
And that video and audio recording, as you sit here today, do you know that that is commonly referred to as a JABS system?
I learned later on, but you always know because you warn people, hey, look, whatever you're saying here today, you have, just like here, you have a camera that's recording everything, so, you know, let's move on, or, you know, you might be in trouble.
Okay. I'm gonna take 1 second here. I have in my hand what's been marked as State's Exhibit 32 and is admitted by stipulation. I already have in my disk drive what is marked as State's Exhibit 32. And this is a DVD disc, and here in the disk drive that you see up on the screen in front of you are the contents of that disc. Have you become familiar with the contents of this particular footage? Have you watched it
I
before?
was recently given an opportunity to take a look at the different files.
Okay. And there are several different files, is that right?
That's correct. There are several different pieces of that basic traffic trial, yes.
Okay. And is that because the recordings are done per particular case?
Yeah, sometimes a case will get interrupted because maybe like an attorney comes in and they have a client, and because you know you're gonna be taking 20 minutes in this one case, if the attorney in his client's case can take a minute, you try to give a courtesy to that defendant and the attorney to hear that case and get them out of there and then go back to really what you're doing.
Okay. And at other times, will the court take a recess?
Yes, or maybe if the parties want to recess, you know.
And so that wouldn't be recorded as part of the case itself?
I don't think so, but this is the only jabs that I've ever reviewed.
Okay.
So other than what you see on TV.
Right, and the JABS recordings of these proceedings themselves are a record of those proceedings?
Yes,
And so that's why you wouldn't have other defendants' cases necessarily on during Mr. Blandino's case in the same
I
report?
presume that's why they would cut off certain parts, why would they show some other defendants' traffic matter?
Okay. So I'm gonna go here. So we're gonna go to this first file. It's a digital file entitled 28-08-2018. That was the date of this particular trial, correct?
I believe so.
And then there's an underscore there of 9/22/58. If that were a timestamp, would that make sense for being a time that you would likely be in the Las Vegas Municipal Court sitting as a judge pro tempore at approximately 9 to 11 a.m.?
I believe the calendar back then was 8 till 11 or 12, depends on whenever you got finished. That's the
Okay.
morning calendar.
What I'm gonna do at this point in time is I'm gonna open up this file.
On record,
All right, you recognize what we're looking at here?
That appears to be a courtroom with me sitting as the judge that day.
Okay. And does this appear to be the first digital video file of the cases on August 28, 2018, specifically involving defendant Kim Blandino?
I believe so.
Okay.
And I see the marshal there too.
I'm gonna go ahead and play this.
versus Kim Bland.
Case number X01152672A, B, C, and D. And
Kim Blandino, Attorney Pro State for Kim Blandino, that's John Corey for the city, bar license 1309.
You don't represent the city, so why are you talking on their behalf?
Because
That's kind of unusual. So
I've noticed that the city attorney in these cases, this is a court of record, it's not entering his appearance as a court number, which is required within the criminal procedure.
All right, so have a seat, sir. Looks like this is a demand for, hey. Nobody talks over me, I'm the judge, right? Sit down. Have a seat. Demand for dismissal of case with prejudice due to violations of speedy trials. I've read the motion and I've read the opposition and anything else for oral argument. Let me start with the defendant.
Okay, the other thing was not addressed in the opposition, the judge read 5 minutes ago, more or less, was the fact that I was asking for judicial notice to be taken of the cases, the statutes that were cited, and I demand now, since it was no opposition, that this court take judicial notice of the statutes, the cases, the federal, the state, that I asked to have judicial notice of the judicial notice taken care of. These are.
I'm going to pause it right here at 1 minute and 27 seconds, sir. Here on the screen, do you see the defendant?
Yes.
Okay, if you could please, you should have a mouse in front of you that may work. Yeah, there you go.
If you can see my, yeah.
If you could go ahead and place that mouse over the defendant, just indicate what you see him wearing in this particular portion of the video.
He's wearing a suit and he's wearing a tie and it looks like a white shirt, looks like a kind of a reddish tie.
Okay, and so then there is another individual that's to the left of defendant. Yeah, right there, that you have the cursor on. Looks like he's wearing some sort of collared shirt without a jacket, is that right?
That's correct.
Who would that individual be?
That would be one of the city attorneys, the prosecutor, for lack of a better term.
Okay, so that's a prosecutor for the city of Las Vegas?
That's correct.
Okay. So is his job to present the evidence in the traffic stop?
Yes, for the city of Las Vegas.
Okay, and now the defendant, Mr. Blandino, here, his role in this case, is he the defendant in the traffic case?
Yeah, he was the defendant and then he also was representing himself.
Okay, and now, it seems clear already, but the individual that we've seen previously in the footage up to this point, on the bench, wearing the robe, it's the judge. Who's that?
That was me.
Okay. And then, here in this frame, these folks that we see in the background, behind the bar, are those just people that are sitting in the gallery of the courtroom?
The two people in the front, I think they had cases, I'm not sure, I'm only speculating. I believe the person in the back right may have been the officer that was going to be called to testify, because in traffic trials, you usually just have, when you get pulled over, the only witness is the traffic officer, so I'm pretty sure, I'm reasonably sure that that's the traffic officer. I don't know who's behind him though.
Okay.
I could be wrong, it just looks like that's a police officer.
Okay, great. I'm going to play it from this point.
Federal case. I gave the docket entries. You've been supplied with the necessary information to evaluate this as something worthy of taking judicial notice of.
Yeah, well, the court knows the law, and there's no judicial notice of all the laws of the land. The bottom line is, you cite the law, and the court interprets the law. Anything else, sir?
No, there's a statute specific.
No, anything else?
Yes, I do, I'm quite a bit.
Okay.
Actually. So anyway,
I looked at the motion, looks like there's 4 points, pretty much, as far as you being, I guess, a quasi-reporter investigator, the religion issue, the speedy trial issue, and that goes with that prejudice issue is kind of the way I saw your motion. So if you want to add anything,
well,
this
just came last night. This is the appeal of the case that I was referencing in, that I had to have appealed on, and so the Supreme Court did docket it. They're asking for the filing fee. It's case number 76794. I'm asking that the court take judicial notice of that. That I have not been able to do any of my investigative work into judicial corruption because I'm having to defend against all these different actions.
Well, this is, hold up, hey, no, when I start speaking, you gotta stop because I'm not listening to you, so I'm just gonna let you know. When I'm talking, what? There's a water fountain outside.
Okay, can I take a recess?
You can run out there, you got about 10 seconds.
10 seconds.
I'm gonna pause it right there. We're currently at 3 minutes and 11 seconds into this footage. Can you just inform the ladies and gentlemen of the jury what it was that they were seeing occur in these particular proceedings at that time that they just watched?
It was, basically, there was a motion that was filed. I had to review it, and then I asked if there was anything further, and I got interrupted a lot. And I tried to, as nicely as I could, have the interruption stop, and then made some arguments. That would be the defendant, and then he wanted to delay proceedings by talking about getting some water, which, you're sitting in the courtroom waiting for your case to be called, calling the case, and you're gonna interrupt what's going on to go get some water, and that's where I guess it cut off, and we stopped it.
So, all that argument that we were seeing going on, the defendant arguing to you about, that was his motion that he was arguing about?
Yes, it was his on his own behalf. The trial hadn't started yet technically. It's more of a pre-trial motion, and the motion is a request of the court. And there was multiple requests in there, like violation of the speedy trial and a few other things.
Okay. Having a motion argument before the court, that's normal, right?
Absolutely.
What about interrupting the judge in the middle of the motion argument that say you want to go get water? Is that normal?
I've never had that happen in my whole career. I've never seen any attorneys do it in court when I'm the attorneys either.
Okay. Go ahead and play it from that point.
Those of you just walking next door and have a seat, make sure yourself. Did I make it?
Perfect.
Did I make it? I hope I didn't.
You know, I don't know. It's more of a figure of speech.
Well, I'm sorry.
So let's go on to, so you have a traffic matter. You have a trial date today, and you have multiple citations. So let's just stick with what we're here today to deal with. You have a demand for dismissal of the case. Do you have anything that you'd like to add to the substantive part? Because really, you're not supposed to, but I give pro se's the opportunity to speak.
So, I'm pausing it right there at 3 minutes and 54 seconds. I'm going to do a quick adjustment as well. You had indicated there, that you give pro se's an opportunity to supplement their motion, is that right?
Yes.
What is a pro se?
I call pro se, there's different terms, just like pro tem judge. Pro se, somebody who's representing themselves and doesn't have the assistance of an attorney.
Okay. So you're giving Mr. Blandino in this moment here when you're talking to him an additional opportunity to provide you anything else that he would like to supplement the motion that he's filed with you?
Correct. Make every effort to have somebody who's not an attorney have every ability to make any arguments that they want to, even if they're extra arguments an attorney normally wouldn't be able to, just because I believe the judges have that discretion, so you're kind of helping them, but you're not representing them, you're just kind of giving them every opportunity to present their case or their arguments.
All right. Court's brief indulgence. All right. We're gonna pick back up on that same footage. Playing it from 3 minutes and 47 seconds.
Opportunity to speak. I'm sorry, I'm out of breath. I'm not in that good a shape. So, what was that last part you said about?
Do you have any, you filed your motion, demand for dismissal, and so what I need to know if there's anything else you'd like to add or like orally express to the court regarding the content of your motion, because we have the motion and we have the opposition.
See, the thing is that this really needs a reply because, number one, you can't really sit at this hearing anyway, because for the same reason, Shannon Nordstrom was on the, she continued it against my will and over my objections. Because she continued it and didn't bring Melworth Winter here, the same reason you can't sit here. I don't know what your name is.
You can't judicial shop. That if you were an attorney, that would be unethical. You don't want to admit that in court.
No.
That's a horrible thing to say.
No.
And you're saying that I have the authority to sit as a judge. Well, guess what I do?
No.
So your request is denied. So let's move on from that. Hey, I'm still speaking. So, do you have anything to add?
I'm going to stop right there, 5 minutes and 11 seconds into the footage. And I apologize if there's just certain context that I would like to make sure that we have as we watch this. We heard the defendant mention some names. One of them was Shannon Nordstrom. Who is that?
I believe that's the current traffic commissioner, and I think she was traffic commissioner at the time I was sitting there. In other words, the judge that would normally be there, but they don't become commissioner.
And there was some other name that he had mentioned.
It may have been some other pro tem. I wasn't familiar with the name, and I think I asked him about it on the video. I'm like, who is that? And I just kind of presumed it was some other judge that he was wanting to have here, but I wasn't sure. I didn't, I was ready to move on from that.
And so
We
it's
still haven't started the trial.
right. So this is the date and time scheduled for the defendant's traffic trial.
Well, at that point, we were probably beyond the time, but yes.
Right.
Trying to get to the trial, trying to rule in the pretrial motion, trying to.
Okay. And at this point in time, what we've just seen is he is trying to get you not to sit as the judge on the case at all.
Yeah, he apparently didn't want me on the case, even though he didn't know me and I didn't know him. And we call that, when you ask for somebody to be removed for no reason like that, and many of that's judicial shopping. That's a no-no 101 for lawyers. That's why I was sorry.
That's inappropriate?
It's very inappropriate to say something like that, but he was pro se, pro per, so I just kind of wanted to move on. Not an attorney, so, just wanted to move on from there, but
okay.
I was pretty shocked that somebody would do that in open court.
Okay, so we'll go ahead and play it from this point. 5 minutes, 11 seconds.
This demand for dismissal before I rule on it.
I'm objecting to your mischaracterization of forum shopping. That's reprehensible, and I don't think you do that.
You already admitted to it. That's okay.
No, I did not.
Beyond that. So.
I'm saying that the law requires.
Okay, so it sounds
by a judge.
So it sounds like you don't have anything else to say. Have a seat.
No, I didn't.
I said have a seat.
I object.
I said have a seat. Anything by the city? In response to the demand for dismissal by this, what's his name, Kim Blandino.
No, Your Honor, the city received a copy of the motion yesterday, so unfortunately the opposition is very brief, but perhaps maybe that's...
Well, Mr. Blandino did a thorough job with his analysis, so, it's easy to rule on based upon the brief, but I wanted to see if there's anything else. I do have this opposition here.
The very brief version of it, Your Honor, is simply that Mr. Blandino has not shown any prejudice to him in this case in terms of the trial date being continued. The city absolutely disagrees with his characterization of the prior trial setting date being continued over his objection. He had every right to go to trial on that day if he chose to. Instead, he made arguments that he wanted only one specific judge, and so that after hearing all that...
Objection. There was nothing on the record on that. I object. He's citing facts not in evidence, and in fact, the evidence is contrary to what he just said.
All right, so, we're not really here to object. We give each other an opportunity to speak just like you're supposed to give me one. Have a seat. Yeah, I tend to agree. I don't have that really in front of me, so let's move
That's
on
fine,
from
Your
that.
Honor, but as part of the city's opposition to the motion to dismiss, the city does not believe in any way that his right to a speedy trial has been violated, and furthermore, he has not been able to show in his his motion any prejudice in this case for the case being continued one time or even a second time. The case has been.
He's not in custody, obviously, so
Correct,
that's a
he's
big
not in
factor in
custody.
my mind if somebody's in custody, because their civil rights or liberties.
Any of the facts that he mentioned in his motion all pertain to other cases that have nothing to do with this case.
Any rebuttal to that, sir? You don't have to stand up if you don't want to.
Well, I will.
Okay.
I do absolutely have it. Again, I want to continue that objection. Elmer Quinter was the person that was required to be sitting on the case. I got certified copies.
I don't even know who that is. You mentioned this name, I have no
If
idea.
you hand
who
this to the
that
judge, I
is.
have a copy I gave to the city clerk.
You can just tell me. I'm only considering what's attached to the briefs, but you can verbally express
He raised this, I think, a board shopping in a sense. You did it directly. He didn't.
Well, listen, no. You mentioned having somebody else and that I shouldn't be here, which to me is kind of offensive. I have no idea who you are. We don't have any, if you were my brother or something like that, well then obviously I'd have some kind of bias probably, and if not, it would appear as though so, and then I'd recuse myself. I have no idea who you are. I do now because of this hearing today, but there's no weight to that, and it makes no difference. You're not a lawyer. So I'm just saying, if you were a lawyer and you admit to forum shopping, that's not a good thing. But we're past that because you're not a licensed attorney in the state of Nevada, are you?
No,
All right.
I'm an attorney in fact.
Okay. Well, you're a lay person representing yourself.
Yeah.
Okay.
All right, so
hold on.
I don't know what you're
Now,
meaning.
You got
Give me your.
Michael Federico.
See, I think, and that's what Joe Reed, the attorney outside the hallway, said. He thought you were sitting on this case. I think you might have represented some of my family members in a prior thing, because I remember Federico. I've got 4 brothers, and I think that I've got to do some blog dive here, because there may be a conflict that I'm not aware of to surprise somebody with the judge.
Listen to me. I have no idea who you are until now. I have no knowledge of any history right now, so it makes no difference. I guess it'd be a good thing if I represent one of your family members, but it's doubtful and it makes no difference. So anything else on the content of your demand for dismissal? All I want is rebuttal to what the city had to say just now.
He said I asked for a continuance or implied so that I was ready to go to trial. Elmer Twinner on the certified copies.
Is that a judge or is that?
I'm gonna pause it right there real quick, 9 minutes and 49 seconds into it. We had heard the defendant making some accusations that you would potentially previously represented one of his many brothers, is that right?
That's what he said.
And at the time, your response was, I don't know anything about any of that, and I don't know who you are.
Exactly.
Now, as you sit here today, do you know whether you've represented any of Mr. Kim Blandino's brothers?
I don't have any recollection. 99.99% positive I've never represented any Blandinos in the past. Primarily over my years that I've represented usually institutions like businesses, things like that, not individuals for any, whatever it is, domestic, criminal, whatever it is. I haven't ever done a whole lot of that. It was usually like, through insurance or through self-insured mom and pop businesses, whatever. So it was a no, and in my mind, I have no knowledge of it, no recollection, so it made no difference. Just like I said there, it makes no difference. I don't know who you are. Let's move on to the trial.
Okay. And just for further background on that, in your capacity as a private attorney, is the majority of your practice civil law practice?
Yeah, I'm considered a civil litigator.
Okay.
A lot of telephone calls and paper pushing and
Okay. And civil being distinct from criminal, right?
That's correct. I did very little criminal.
Okay. Like this case here today would be a criminal case.
Criminal is when the state is bringing charges as opposed to civil where, Mr. A and Mrs. B are suing each other for something. That would be civil.
Okay,
It's when the state is not directly involved.
we'll start the video again from that point, 9 minutes and 49 seconds.
Referee or something like that? Yes, from what I've been told, only what I've been told, the traffic commissioner, that's still listed on the paperwork. You cannot surprise somebody, it violates due process to surprise somebody with a surprise judge.
Let me just
You made that up a phone just
hold on. I said justice court over, I've appeared in front of there on the morning of a murder preliminary hearing. There's no issue in county. And over here, I sit in other places too, trespass, domestic violence. And here we are in traffic. And so I would suspect that if your position was right, I wouldn't have been filling in since 2001. So we're past that argument because your demand on that argument is denied. So let's keep going.
No, just because some of the people waive their rights to a possible disqualification issue does not mean I'm required to.
Listen, the record is noted, and it is denied this time, sir. So anything in response to the city's argument here today?
I demand that this court take judicial notice of this certified document, just got it yesterday, that shows that Elworth Winter was the one that will be presiding over the trial. This is certified. This is a court of record. Well, if I take this up to appeal to the district court, they do that appeal on the record, not what our oral pronouncements are.
Okay, well, here's the deal. You made your record. No, I'm not going to. Your request is denied. Anything else on the substance of your demand for dismissal in response to the city's arguments against it?
You're totally discounting the possibility that there is a disqualifiable issue related to me due to representation by a relative or some other factor. And to merely presume and not to give me time, because as of coming in this morning.
Okay, have a seat. You've already made your record. This is all being recorded, so that's good.
I know that.
We don't need to repeat it multiple times. It's already on the record. So anything else, anything new that you haven't said already, sir?
Yes.
Well, go ahead. I've been waiting.
I need another drink of water. I get, I'm
Do we have some water for him so he doesn't run around here? Go.
That sign, there's 3 signs out there saying,
Listen, stop complaining, have a seat.
Just stay.
I said stop complaining and just have a seat, please. Let me get you some water. Anything else you'd like to say in response for because I have the briefs, I've read the briefs, and I've heard you keep on repeating the same things. So, anything else?
I object to that mischaracterization.
So you object? Go ahead and object all you want. It makes no difference. It sounds like you're finished?
No. If you're going to, it sounds like you're going to deny this, you want to rush the trial, you want to rush the judgment.
Rush the trial? You said you didn't have a speedy trial. Now you're saying we're rushing it.
No, rush the trial.
No, just have a seat because you're not making up. Have a seat. You've already said your piece. You just said that you don't want to be rushed for the trial, and this was partly saying violating your speedy trial rights. That's impossible. Have a seat. Have a seat. Listen to me. Listen to me. One more outburst and hold you in contempt. Okay, thank you. So, with that, I have the demand for dismissal of case. I have an opposition. I looked at the demand for dismissal as being based upon issues with the judge, issues with being a certain reading.
And now at that point, the Javs courtroom video cut out for a second, is that right?
I believe so, yes.
And then it picked back up moments later?
It looks like that's what happened.
Okay, so we'll go to the next video file, which is on State's Exhibit 32 and entitled 28-08-2018-09-37-04. Yeah, absolutely, I can repeat that. The title of this particular digital video file is going to be 28-08-2018-09-37-04.
and it is a .avi file. I'm going to be opening up that digital video file right now.
Who knows? I mean, anybody can speculate all day long. I've been practicing law for a long time, and I've been a building judge for quite.
Here we have that particular video up on the screen. Does this appear to be the continuation, minus maybe a few seconds of coverage?
Sorry, it looked like it wasn't moving. I'm not sure if it was still in that.
Okay,
But I think it's a
This
continuation.
video.
Just I don't think anybody was.
you're
moving.
right. Thank you very much for bringing that to my attention. All right. Playing that digital video file now.
Who knows? I mean, anybody can speculate all day long. I've been practicing law for a long time, and I've been a building judge for quite a while. So I deny that part of the motion. I don't know this individual. At least it's not in my brain right now as we sit here today. There's no prejudice, despite all the outbursts that the mayor is speaking of me. I really don't care because it happens a lot. So, as to the religion, this court, it makes no difference what religion you have, or if in fact you have no religion. It makes no difference. I, as the judge, hear cases on the merits. I don't care about anything else. And frankly, it doesn't really bother when people cut me off, get excited, want to run around, go get drinks of water, interrupt when I'm talking. It makes no difference because ultimately I rule on facts. And that's all I'm going to rule on, just like in this case. So that part of the motion is denied. As far as the speedy trial issue, there's none. You're not in custody. There's no prejudice. If there was any prejudice or any ambush to you, you wouldn't have been able to have time to prepare this lovely 15-page brief, which took me some time to review. So had there been any kind of prejudice to you, definitely you would not have had time or any kind of ambush. As far as speedy, I believe that the case is being heard on time. I'm not sure if you switched your position because you just told me that I'm rushing your trial after you put a violation of speedy trial right. Listen, I'm still talking, but it makes no difference to me. I don't see the prejudice. I can see you're well prepared, and you speak a lot more than most attorneys that come before me. So with that, the motion is entirely denied. We had a trial 9 o'clock. However, we're not going to throw you into trial right this second. A little bit out of breath. You ran outside, need some water. So we will trial it so we can have a trial after a couple more hearings are heard. I wouldn't have done that anyway, even if you asked for it. Shit, so everybody else can have their cases before we do the actual trial. And don't tell me that you're not getting your speedy trial because you can't have a right this second because a half hour from now is not going to affect your rights. Okay?
Can I speak?
No. Not until we do trial. Like I said, your objections have no effect on the ordinance. It was the motion that we just heard. So if there's anything else we're going to trial, we'll deal with that when you're in front of me in trial. So with that, have a seat. How long do you think, how many cases do we have in front of this gentleman?
We have 2 motions.
We have 2 motions, and then we have trials?
There's 2 consecutive and 1.
2 trials, okay. And how many, do you have, hold on a second, hold on. You have any witnesses here?
Not on the other trial.
Well, this, we have 2, what about this one?
This one, I do have a witness for the Blandino.
Who's that? Is he here now? You got him here?
He's here.
Okay. So, take an ordinary course today, so don't leave. Make no misunderstanding of what.
I'm asking if I can go to district court.
Go to where?
District court,
For what?
give an emergency stay on a daily basis. Because you're out of line.
Listen, have a seat over there, and we're gonna have your trial today, just like everybody else gets their day in court. Okay? Thank you. All right, next.
All right, sir, so that video that we just watched, did that appear to be the continuation of the first video?
Yes.
And what did we see happening there?
Well, he was making more arguments and also just simply arguing. It was more of, seemed like it was more of delay tactics. In other words, hey, well, the police officer's here, so let me digest this stuff and we'll continue this another day. Hey, I don't like you as a judge. I think you're representing my family, which I don't know why he would have a problem with that then. And let's continue this, even though in the document that I submitted to you, I requested a dismissal because my trial didn't come fast enough.
And so you ruled on his motion,
Yes,
you denied it,
yes, I believe I denied all parts, I'm
okay?
pretty sure.
And then it ended taking a break or continuing the trial. What was happening?
Like I was discussing earlier, there's some other cases, it looked like it was a pretty light load, or maybe there was more of the general public was in earlier. I don't recall, there was that day, at that time when this video started, it looked like it was a very light load, and it sounded like there was a few other matters to hear, and then there would be, I think I said, 2 trials. So we just assume some really quick things so that we can get and take time and focus in on the trial is gonna happen. And especially now, the way the foundation's been laid on what I'm gonna expect with this trial after all of the time spent with the one motion.
So you take a break to be able to get the other defendants, witnesses, and attorneys' cases done and out of the courtroom?
Right, there are subpoenaed witnesses, sometimes people from out of state, you have traffic officers in there that could be doing something better than just sitting there. So you want to get cases done, in other words, if there's another trial set, but you've been told by the defense attorney and the city that the case is resolved and it's not going to go to trial, then I can take that plea and then the witnesses can be excused and they're not just basically stuck in court all day. It's just, it's common sense, it's just a matter of, it's what judges come to do.
Okay. Your Honor, may we approach? Thank you so much.